Hereditary titles, in a general sense, are titles of nobility. Positions are styles that are hereditary and thus tend or are bound to remain in particular families. Though both monarchs and nobles usually inherit the titles, the mechanisms often differ, even in the same country. The British crown has been heritable by women since the medieval era, while the vast majority of hereditary noble titles granted by British sovereigns are not heritable by daughters. Gender preference. Often a hereditary title is inherited only by the legitimate, eldest son of the original grantee, or that son's male heir according to masculine primogeniture. In some countries, titles descended to all children of the grantee equally, as well as to all of the grantee's remoter descendants, male and female, in the legitimate male line. Historically, females have much less frequently been granted noble titles and, still more rarely, hereditary titles. However, it was not uncommon for a female to inherit a noble title if she survived. All kinsmen descended patrilineally from the original grantee, or, in England, if she survived just her own brothers and the male line descendants. Rarely, a noble title descends to the eldest child regardless of gender. A title may occasionally be shared and thus multiplied, in the case of a single title, or divided when the family bears multiple titles. In some traditions, inheritance by adoption is an alternative to inheritance by biological kinship, as in the Hindu tradition, to assure there is a male heir of the same caste. In the French nobility, often the children and other male line descendants of a lawful noble title holder self-assumed the same or a lower title of nobility, while not legal. Such titles were generally tolerated at court during both the ancient regime and 19th-century France as titres de courtoisie. Examples: hereditary monarchy in Bhutan, Brunei, Cambodia, Japan, Thailand, Tonga, Belgique, Denmark, Luxembourg, Liechtenstein, Monaco, the Netherlands, Norway, Spain, Sweden, Jordan, Morocco, Qatar, Saudi Arabia, Kuwait, Oman, Bahrain, Lesotho, Swaziland, and the Commonwealth realms. Other national constitutions use different modes of succession to their monarchies, e.g., the election of the Pope in the Vatican City, and especially in the Orient, often adding an element of selection among eligible relations of the monarch. Special cases of the two elective monarchies, Malaysia and the United Arab Emirates, where the constituent states of each federation are hereditary monarchies, but those rulers form an electoral college that assigns the federal position of head of state to one of the number for a term. Titles of nobility in the United Kingdom and other countries. In the United Kingdom, most titles of nobility pass only to the eldest son. All other sons and daughters of peers are commoners, though they may use one or more not independently heritable courtesy titles, either Lord, Lady, or the Honourable, depending on the rank of the peerage held by the father or mother, or another title styled like a peerage but without a seat in the Lords, usually one or two ranks below fathers. In many European countries, titles may be inherited by all the heirs male of a family, whose members thus all share the same title at the same time. In the Far East, the main tradition is rather for titles to devalue as the generations succeed each other, but not to the same rank. Hereditary chieftaincy, manifested in countries in various parts of Africa, Asia, South America, and Oceania. Examples range from the powerful to the merely titular. Some court titles, e.g., in the United Kingdom, including Earl Marshal and Lord Great Chamberlain. Most of these are sinecures, purely ceremonial. They passed generally to the eldest son. Many other, especially feudal-age, offices became inheritable, often connected to military and/or domanial functions, which is also why some such functions became noble titles. While the hereditary membership of a privileged class or caste may imply a title or not, it frequently forms a prerequisite for various titled positions, e.g., quarters of nobility required by a military order, certain religious positions, such as the Aga Khan and the al-Mutlaq. Coparcenary. Coparcenary is where two or more people inherit a title equally between them, as a result of which none can inherit until all but one have renounced the right to the inheritance. This could arise when a title passes through and vests in female heirs in the absence of a male heir. Before they could inherit, each of the female heirs would be an heir presumptive. After they inherited, since the title could not be held by two people simultaneously, two daughters who inherited in this way would do so as co-partners. In these circumstances, the title would in fact be held in abeyance until one of them renounced for herself and her successors in favour of the other. In England and Wales, passage of a title in this fashion is effected under the rules laid down in the Law of Property Act 1925.